They do an investigation, the investigation runs its course, and if they can't proceed to a prosecution and there's no other way of disposing of the allegation in terms of a criminal prosecution, a caution or a reprimand, then a senior officer has to make a determination what to do with that particular investigation, and that's when they'll decide to use this form.
So they're innocent, in other words?
No, what it means is that there's an allegation been made and that allegation has some merit, but it is not enough to proceed to a criminal prosecution.
But if there's not enough evidence to proceed to a criminal prosecution, they're innocent?
No, not necessarily. There's still an allegation that's been made. The allegation has been made, and sometimes these allegations have merits, but they don't get to court because the victim doesn't want to proceed with a prosecution. There's lots of technical issues. Sometimes CPS don't want to take the case to court. So the idea is that rather than just file the case as undetected, what the officers are asked to do is to visit the person, speak to them about their conduct, ask them to look at the law, which the form points out to them, and ask them to consider adjusting their behaviour under those 5 areas, the 5 Cs.
What do you think, Sandra?
I think that this option fundamentally misses a step which is already built into the legislation. There are sexual risk orders which are available. They are made once a person has committed a sexual act which it is deemed to cause potentially a risk of harm in the future. So a public protection tool is already available. All the police need to have is reasonable cause to believe that there may be harm in the future. It's a civil order. It's supervised by the court, it lasts for a minimum of 2 years, and it provides all the support and assessment that you would expect. Most importantly, there is some oversight, judicial oversight, regarding the assessment made concerning the person's behaviour.
Where is this?
Absolutely none. So that, no specificity regarding exactly what is alleged, no opportunity to seek legal advice, no opportunity to contest the information on which the order, the notice is based.
How do you respond to that?
Well, that's not completely correct. The idea is that an investigation has been done by the police, that the police have thoroughly looked into the allegation. If they have nowhere else to go with the allegation, their only course of action is to file the crime as undetected. Now, the crime is still filed as undetected, but what they say is we've spoken to the person who is subject to the allegation and we've given them some advice about their conduct. And ultimately, if that person then commits an offence, that can be used at a later date. If that person never comes to notice again, then that never ever gets used. It simply sits on the record within the police station.
Let me bring in Police and Crime Commissioner for Northumbria, Dame Vera Baird. What do you think?
I think that the lady who spoke has said the right thing. The first obligation on the police in a situation where they can't go further with a case is to see what risk there is from this individual. And they must assess that because there may be a risk to children. And if there is, and if they've got any evidence that this person has done a sexual act of any kind, it doesn't have to be an offence, it doesn't have to be half an offence. If it's something that can show the magistrates that there is a risk from the person, then they can get a sexual risk order and they can make very clear, you mustn't go near that school, you mustn't go here, you mustn't do that, you mustn't do that. It's a criminal offence if it's broken, and that is a real way of dealing with this. The difficulty about notices, and nobody can criticise anyone for innovating or trying to innovate, but the difficulty about notices are first, it really is very difficult for the individual to deal with it because, frankly, if you came to me and said your sexual behaviour is causing us concern, we think you may have been involved with assaulting children, this is a list of the things you'll be prosecuted for if you carry on doing what you're doing, I'd show them the door. But some, relatively vulnerable person may agree to sign it, and what are the consequences of signing it? I think that's quite worrying. But the HMIC, the Inspectorate of Constabulary, have said that this kind of notice, because there was something called a police information notice, which was very similar but in regard to harassment, these have been used in a multiplicity of ways which are not wise to use. There's a huge financial pressure on policing now, and although your speaker here makes it sound as if it would only be in the absolute last analysis where nothing else can be done that this is used. Firstly, there are a lot of other things to do in the meantime, and secondly, with a lot of financial pressure on somebody, how long does it get before, well, this one is far too expensive to take forward, give him one of those notices and that'll be the end of it. This notice protects absolutely nobody.
fundamentally, quite clearly, I disagree with both your speakers here today. The forms are working really well in Hampshire. They've served 54 forms. 9 people have come to light.
In 2 years,
and at the end of the day, what we're seeing is it's a really good way of communicating, particularly to people in a younger age group, that they should think about their behaviour. Because
2/3 of the 54 notices have been handed out to under 25s, but 9 people went on to commit an offence. So how are they protecting people?
Well, at the end of the day, you can't legislate for people that go on to commit an offence. So this is about a prevention. This is about a prevention strategy woven into part of Hampshire's prevention strategy.
And why is it better? Why is this C5 notice better than a sexual risk order?
Well, because you can't always get a sexual risk order, okay? And 9 times out of 10, what you're looking at is you've got an allegation that if you just file that allegation, that's just not sufficient to say, well, we've not done anything, we can't proceed with the prosecution. But if you actually say we've been to see the person, we've spoken to the person, we've given them some advice about their conduct, whether that person chooses to act and whether that person,
any judicial oversight.
well, there is
Yes,
oversight.
exactly.
It's
Not
oversight by an
oversight.
inspector or above within the police service.
But does an individual have a chance to reject it, to say I'm not signing it?
Of course they do. Yeah, it's a voluntary process. It's not a compulsory process at all.
The difficulty with that is that
people
while
are going to know that. I'm not
difficulty
sure
is that
people are
while
going to
you
know
might
that.
be able to refuse to sign, it's still logged against you, so that it has an implication later on. If you decide to adopt, you decide to emigrate, you are in touch with social services, this is information that will come up at that point.
In an enhanced check.
Exactly.
Well, it
And
won't
you
come
have
up in a
no
DBS
opportunity.
check. It's not subject to the
That's
DBS
not
check.
true.
Well, it won't. It won't come up.
The
It's
police
subject
national
to.
computer allows them to disclose information if the officer who is undertaking that task thinks it's appropriate. Which officer is going to take the risk of not disclosing information that suggests that there is a risk of child sexual abuse?
Do you know, there is a slightly further worry, which is that this, you know, if signed, it does say, look, your sex behaviour is causing us a worry. We think you may have been involved with children. And so if they came to my door, as I say, I'll just show them the door. And if you don't do that, why are you going to be seen to have been taking them in and saying, oh yes, all right, you think I am doing this? These are all the laws that I'm going to break if I don't stop. I'll sign here to say you've just said all that to me. I think that's a quite small stretch before it's really going to cause this individual difficulties. It's done without a lawyer there, and it's done without the intervention of the court. It is very much better to go to the court and get a sexual risk order, and frankly, if it's as many as 50 in a couple of years, it's playing absolutely no role in stopping child sexual exploitation, which is very, very endemic and needs really hard work from policing. I think, you know, let's applaud innovation, but I think this will play no role at all.
2/3, as I said, have been handed out to under 25s. Now, one example I've been given is, for example, an 18-year-old man with a 15-year-old girlfriend, and they were sexting each other. So is this about trying to not criminalise young people?
Partly some of that is that sometimes people, when they go to court, when there's enough evidence to take to court, then the police and the Crown Prosecution Service are quite happy to do that. But sometimes lots of these cases just sit in a void. There is not enough evidence to proceed to a prosecution. The conduct is quite clear. And so what do? You just say, well, OK, let's file this as undetected? Because the police are in between a rock and a hard place with this. If they don't do anything with it, if they don't try and warn someone about their conduct, if they don't try and address it as part of a prevention strategy, then if that person does later on come to light, everyone says, oh, well, you knew about that person, but you didn't do anything about it.
No, there are disruption tactics which are used day in and day out by the police, and what I think would happen in Northumbria if they've pursued this and they can't take it any further is that they would then get an intelligence picture of that individual, and they would start to look at ANPR, they would start to see where he goes, they would perhaps do some surveillance, they would certainly tell all their partners, as they're entitled to do under child concerns. They can give all the information for this individual to be noted wherever he goes. They will try and draw up an intelligence picture and hope that in the end they can in fact do something against him. It is not a case where people just say, oh, it's too tough, this one, we leave it alone, and in comes the form to the rescue. I think the form takes the matter no further, that they will try to do all of that.
Okay,
that's not what we're saying. We're not saying this is too tough. We're saying that an investigation has been completed, an investigation has been run, there's no evidence to support a prosecution. So this is an option for police officers to decide that if it meets the threshold, they can go and visit the person, give them some advice and ask them to adjust their conduct.
And what is the threshold?
The threshold is that there's no evidence to support a prosecution.
So there's no evidence, so they're innocent.
No, there's two different things, Victoria. One is saying that the allegation has some merit, and that's for a senior officer to decide. There's lots of allegations that are made that never proceed to court. And so it's for a senior officer to decide whether it's appropriate to serve this form.